Welcome to the Your Life, Your Money podcast with Scott Searins, teaching you how to thrive in life, wealth, and retirement.
Welcome to the Retirement Show, all about your life, your money, and today we're going to talk about your estate plan. So I'm your host, Scott Searins, and my goal is to help you thrive in life, wealth, and retirement. And we have a special guest with us here today, Lauren Jackson. Lauren is a licensed attorney in the state of Illinois. So here to talk to us about what does it mean to have our legal affairs in order? What does it mean to have our estate plan together? And so many people are always like, I'm going to pass away. I'm going to die. Why do I even have to do this? So Lauren's going to share that with us today. If I have my information right here, licensed attorney since 2003.
Since 2003.
And you can kind of fill in the gaps here, but then you started your own firm in 2014. Is that correct?
Yeah. Well, the end of 2014. Really, it was 2015.
Well, cool. So congrats coming up on your 10 years there.
Yes, it's unbelievable. I never really paid attention.
Awesome. So welcome to the show, Lauren. Thanks for joining us today. And how about this? Fill in the gaps for us. How did you, where did you practice in the past? And then when you started in 2014, what are your, areas of focus now? Because I know there's so many different attorneys out there, and some people focus on divorce and some people focus on litigation, and I have no idea, right?
Yeah.
It shows that I don't even know. So if you don't mind, kind of fill in the gaps for us.
Well, it was a process of elimination for me, really. I started off at a firm in Palatine, and I was the youngest of a handful of attorneys, the newest, and kind of stuff rolls downhill, and the practice areas that nobody else wanted to do, that's what I wound up doing. So I did some bankruptcy, some collection, a lot of residential real estate closings, because it's a lot of busy work and not everybody wanted that high of volume. So I did a lot of that, and then the estate planning work.
Okay.
And so over the years, I kind of was able to pare down out of all of these areas that I'm practicing in, what do I like?
Got it.
And I figured out I did not like litigation, which a lot of
we all have our
attorneys
likes
don't.
and dislikes, right?
Yes. And it's not how it is where you watch it on TV. Even like the litigation work on TV seems exciting and quick moving, and it's not. It takes years and years and years.
Okay.
And at the end of a litigation process, usually no one's happy. Everyone has to settle for less than what they wanted.
That doesn't sound fun at all.
It wasn't fun. And then I also clerked for a guy who was doing divorce work.
Okay.
That was zero fun.
Okay.
And I came to learn that I wanted to focus my practice on areas where I felt helpful and useful and where the client was getting value. And today, really the favorite part of my day is at the end of an estate planning process or a real estate closing, and the client just looks at me and says, "Thank you so much. You made this so much easier. This is a relief." And I feel like I've added value to somebody else's life and I've helped them,
Awesome. So your main areas of focus now at your firm?
So in 2014, we had my first daughter.
Okay.
I was working for a title insurance company, handling title claims. So real estate related work. And that was like a Monday through Friday, 9 to 5, get up, leave the house, be gone all day. And my husband at the end of my maternity leave said, you've been doing side work here and there for family members, real estate closings, estate planning. Why don't you just try and do that on your own and start your own practice?
Yeah.
And I was terrified. And I knew I could do the work, but I didn't know how I was going to get the clients. And my husband got a book from the library and this was years ago, right? So he actually went to the library and got a book on law firm marketing and helped me create a website and helped me get good Google placement. And ever since then, it's been People find me on the internet, word of mouth.
You guys got quite the team going on.
Yes. I'm very fortunate.
Yeah.
Yeah.
Because he's a full-time firefighter, right?
He's a full-time firefighter.
Yeah,
so his side gig is
marketing your business. That's awesome. Yeah.
Yeah.
Oh, that's awesome. And so I know we've been doing, a lot of workshops and seminars together, retirement seminars, helping people out with just planning for their retirement. And, part of our seminar is just that, like planning for the estate plan. It's, for me, it's interesting. I would say in dealing with a lot of like retirees, so people call it age 55 plus, the number of people that come in that haven't done anything about estate planning. Do you have a will? No, we haven't decided to do that yet. How about powers of attorney? No, we haven't done that. And they probably had kids too. So how they got from point A to point B, and we'll probably talk about like why that's just an area of concern right there. But just don't have it in place. And so I know two things that are probably going through people's minds. One is that, well, if I do this, something's going to happen to me. I'm sure you hear that, right? Or people feel that way. Like if I go and sit down with Lauren,
they think they're going to jinx their life.
Yeah, jinx their life. That's a good way to put it. And then the other, I think sometimes is just, why do I even need to put this together? Because I'm going to pass away. Like, isn't it somebody else's problem to deal with?
Yeah.
And so maybe touch on that first. Like, why do we even need to think about, whether you call it having our legal affairs in order, estate planning? Some people are probably listening going, well, I don't even have an estate. That's probably for like somebody with a lot of money.
Mm-hmm.
Like, so let's just narrow it down. Wills, powers of attorney. Like, why do we even like need to have these things created? And if I asked you like, what are the bare essentials? So first, why do we need to have them created? And then what are like the bare essentials like somebody needs to have in place?
Right. Because I'll be dead, so what do I care?
Yeah.
Yes.
Yep.
That's what I hear a lot. And if you have ever had someone in your family die, and perhaps you were in charge of settling up their estate, marshaling their assets, and making sure they get distributed, it's a process. And it can be lengthy and painful if the person who died hasn't done any planning. Mm-hmm. And so the real main focus for doing an estate plan is to make it easier for your kids, for your heirs, for whoever you leave behind. And so it's really a very kind and loving thing to do for your family.
And when you say assets, just so like, I want to like keeping it super simple for people today. That could be a car, right? A house, the jewelry sitting on the countertop, I assume. Is that part of just assets? Is anything and everything that you own that somebody else is going to get?
Yes.
Is that true?
Assets and liabilities.
Okay.
So, maybe you don't have much of an estate. I've had clients come to me where parents passed away and all they had was an apartment and a car. But they still have to deal with Social Security. They still have a small checking account. And if no planning is in place, it can become really time consuming and problematic for the kids to be able to kind of settle up and close out these things. Even some landlords won't deal with anyone until a probate estate has been opened. And so that's kind of the point of having at least a will and maybe beneficiaries set up on everything.
Okay.
And so really your main bare bones component to making a plan is having a will and at least a power of attorney for healthcare and a power of attorney for property.
Okay.
And the powers of attorney, those are documents that only take care of you as if you're alive, but you're incapacitated.
Okay.
So when someone dies, the power of attorney cuts off. And a lot of people have a misconception that they'll be able to use mom or dad's power of attorney to kind of settle up and close out their bank accounts after they die.
So not the case.
No, unfortunately,
no. A lot of people think that, like, oh, this is my rights to be able to like go write checks for them still and go everything, right? But that you're saying that totally stops. So
Yes.
my parents pass away. I'm their power of attorney. I walk into the bank and decide to write another check. They're going to be like,
No.
Sorry, can't do that.
And in reality, what happens is as soon as the financial institutions find out that the account holder is deceased, they lock the accounts.
Okay.
And no action can be taken on them.
Okay.
Unless there has been some kind of plan put in place.
And is that the will then, or is that?
It can be.
Can be. Okay.
It can be.
So let's start breaking these down a little bit. We can start wherever, but you kind of were talking about the powers of attorney there. And you mentioned, so there's health.
Sure.
And property.
Yes.
Which one do you want to start with? Health? Why?
Health usually, because that's like the first one that someone needs to use.
Okay. So why do I need that in place?
So the healthcare power of attorney makes it so that you're giving somebody else the ability to make your decisions for you in the event you're incapacitated with regard to your health care.
Okay.
So a lot of people have the presumption that their spouse will be able to make decisions for them. And there are some hospitals who will allow a spouse to do that. There's others who won't. And they require that a power of attorney be in place.
Okay.
For healthcare. It's especially important if you're not married, maybe your spouse has died or you never got married in the first place. In that event, even like your quote unquote next of kin won't be able to make decisions for you unless you have signed a power of attorney naming them as the person with the ability to make your decisions. So with the power of attorney, it's really important that you name somebody who is in your life to some extent, because you got to imagine, I have a catastrophic situation where I have a stroke or a heart attack or something. I'm at home. Who's going to know? Or if I'm able to call for help and the ambulance comes to get me, it's like, how is anybody going to know to show up for me? So having someone who's geographically close is super helpful, in my opinion.
Okay. Can you name more than one person as your power of attorney for healthcare? And is that like recommended? Or so let's just say there's two kids and parents are like, I don't know, let's just name them both. Good idea, bad idea, thoughts?
Illegal.
Oh, okay.
So Illinois has a law in place that says that only one person can act at a time as power of attorney. So naming co-agents is prohibited.
Okay.
It used to be allowable, and I think there was a lot of litigation that was going on between co-agents that couldn't agree on decisions.
Probably not. Yeah.
So,
everybody has some different emotional thoughts, right? So one person might think one way, one person might think the other.
Yep.
Okay. Yeah.
Yep.
So one person, is there a backup?
As many backups as you want.
Okay.
And so, I mean, I try to push people to find somebody on a generational level below, is how I phrase it, instead of just saying you're old, pick someone younger. Because as we age, we want our documents to be able to age with us. And if you name someone who's older than you, obviously, the longer you live, the older they're going to get, and eventually they'll die, and then you'll need a backup.
Yeah, would they even be able to make those decisions for you, even if they were still alive?
Correct.
And so, okay. And then what about if somebody doesn't have children? I'm certain they've come into you and go, all right, Lauren, I don't have any kids. So then like, who do I go to name as like power of attorney for healthcare?
Well, for either healthcare or financial decisions, there are no professional organizations that you can phone up that provide that service. So it's really got to be an individual person who you know.
Okay.
So normally people go to closest family members like siblings or cousins or nieces and nephews.
Trying to keep younger.
Yes.
Yeah.
But if you've got a sibling who's maybe 5 or 10 years younger than you, I say go for it if you feel comfortable naming them as your decision maker. Otherwise, if you've got a dear friend that you've had forever and always, I've had people name those types of agents, as we call them, as their decision makers. So, really, you've got to stretch your imagination sometimes to dig deep and come up with who's going to be able to make these decisions for me. But usually you can think of someone.
And now you said it only kicks in if you're incapacitated. I was worried I wouldn't say that word right. So incapacitated. It only kicks in if you're incapacitated. What does that mean?
Well, the power of attorney, it's a form essentially in Illinois. So the Illinois statute that the legislature enacted has the specific language for the document right in there.
Okay.
And it includes 3 options. And so when the client comes in to sign the healthcare POA, there are 3 options and they have to select one for when your agent's decision-making authority kicks in. And it's either once my treating physician has determined I am incapacitated.
Okay.
The last option is my agent can start making decisions for me starting now, provided I can make my own decisions if I want to, but if I don't want to, it can default to my agent.
So you could be totally fine and you're really giving that ability up to somebody else with that decision. Oh,
yes.
All right.
Yes. I've only had a couple of people select the last one, and honestly, it's my older husband and wife couples. And the husband just looks at me and says, she makes all my decisions for me anyway, so.
Might as well just keep it the same.
Yes. I don't pay attention when we go to the doctor. If I had it my way, I wouldn't go to the doctor.
So it's a good option for that case.
Yes.
All right.
So
and then what's in the middle?
Particular to everyone. So the one in the middle is a little goofy and people often get confused by it, but the first sentence is the exact same as the first option. So you retain your decision making until you can't. However, starting the day that you sign it, for purposes of assisting you in your healthcare plans, you're going to waive your HIPAA privacy rights with respect to your agent and allow them full access to all of your medical records so that they can make doctor's appointments for you, come to appointments and listen in, and then throw in their 2 cents about what they think. So I have a lot of married couples who make that decision and select that second option starting the day they sign it. Even if maybe they don't go to each other's doctor's appointments now, they're seeing into the future that would probably be what happens. And so they just decide right now, while I still have my wits about me, I'm making the decision that I want my spouse or my backup children, for instance, to be able to have access to my records because I'm transparent. I'm okay with everybody knowing what's going on with my healthcare. And it does help, I think, in the long run, be able to give transparency to your kids. And the whole point is for the healthcare power of attorney to benefit me, right? So that I'm getting the best care possible because I don't always know what's best for me.
And I mean, yeah, if we kind of really, I mean, okay, we've just been talking power of attorney and healthcare and incapacitated, but just kind of like reality for this whole thing is you're most likely in the hospital or at a point where you're not able to make decisions on your own, do the best job of taking care of yourself on your own. And so you're just saying, I want help in doing this.
Yes.
Wherever that might be, home, in the hospital, at the doctor's office, depending on which option they selected. I want help doing this. Any, I'll say, stories or examples, what then happens if somebody doesn't have it in place?
So if you don't have a power of attorney in place and your spouse can't make decisions for you for whatever, or you're what I like to call the last man standing, and now it's just you. You've got children maybe, but without the power of attorney, they don't have the right, and the hospital can't take direction from them unless they apply for full guardianship over your person, which is a court process.
It doesn't sound quick.
It's not. I mean, you can try and rush it, but it still takes several weeks and it's expensive because what happens is someone needs to volunteer to take over all of your decision making for all of your health care. But in order to get that power, a judge has to give it to them. So they have to apply for that in probate court. I've had people try to do it themselves and get partially through the process and then realize it's too much. And the courts and the clerks can't give you direction. So they end up hiring an attorney to either step in and continue or fix what they've done wrong.
Okay.
The first step is you have to get a written evaluation from a physician stating the person, who we now call a ward. Nobody wants to be called a ward, but that's who the incapacitated person is.
Yeah.
And a physician has to determine based on a neurological workup or a physical workup that they can't make their own decisions. And usually to get that report from a doctor, you have to pay for it. And insurance doesn't always cover that. As well as like the court process, somebody has to pay for that. And there's no insurance that's going to cover that. So already to do a full guardianship proceeding in Kane County, my office charges a flat $3,000. And somebody's got to come up with that money. On the back end, they can be reimbursed out of the ward's estate. So you can pay yourself back out of the person's assets, bank account, savings, whatever they have. But that's then depleting the money that the person who's having the issues has available to them.
And then they're sitting in the hospital while all this is going on.
Yep.
And if they're not able to make decisions, is it then the doctor's just supposed to make their best decision? Where does the decision making go to?
Well, doctors have a responsibility to you to keep you alive at all costs, right?
Okay.
So that's what they're doing.
Interesting.
And running up a
So
medical bill.
Have it in place. And I mean, obviously, it's just the obvious that's going through everybody's mind now. But but I'm just saying what I'm thinking as I'm going through this. Have it in place. And even if I check the box with I don't want to give over any sort of power until I'm fully incapacitated, at least then somebody can come over and start making decisions for me versus the doctor just doing what you said, that they're supposed to keep us alive at all costs versus... So then that part can take place. But if I don't have anything in place, then the doctor keeps me alive at all cost. And my children or brother or sister or cousin or niece or nephew have to go through this process that could take days or weeks.
It's weeks.
Then to be able to help make a decision. I
Right.
mean, it's okay. So
It's bad.
get that in place.
It's bad.
Get that in place.
And
I mean,
you got to
for
remember
sure.
with the guardianship proceeding, you don't have any control over who's making your decisions. You could have somebody volunteering and petitioning to make your healthcare decisions who you don't want making your healthcare decisions.
Yeah. Now, one of the things I think people always wonder about, I wondered about it until we were doing our workshops together. Is this the let's just call it the pull the plug document? I think everybody's like, well, am I giving, my spouse or am I giving my son or my daughter, am I actually giving them the pull the plug authority? So is that what this document does or no? Where do the lines come in there?
It can be.
Okay.
I mean, you've got whatever plug people think is getting pulled. I mean, your agent has the ability to make that decision to stop whatever treatment is happening.
Ongoing treatments or Sure.
But the pull the plug document is more of a DNR, which is a do not resuscitate, which says if my heart has stopped, don't start it back up.
Okay.
Which is very different from, well, do you get nutrition? Do you get oxygen? Do you get pain medication? Things like that. So the DNR, I don't prepare because a physician has to sign that at the time that you sign it. Your doctor's office has it, and I just tell people to go there to get it if they want a DNR in place. If not, the healthcare power of attorney is really designed for longevity. So it's more of the document where perhaps my mind is gone, but my body is chugging along just fine. Mm-hmm. It's a number of years during which time somebody else is going to need to be making decisions and really quarterbacking my care. What I've been hearing recently from clients is that if there isn't someone there advocating for their mom or their dad, all of a sudden there's like a plethora of doctors and everybody's wanting to treat everything. And she goes in for one thing and he refers her to somebody else, and that person starts doing some things and then unearths another problem and refers her to somebody else. And before you know it, you've got 6 or 7 different doctors that you're seeing on a regular basis for different things. And at some point you need to decide whether or not you're really getting the best care, or are you just paying a lot of providers unnecessarily when maybe we compare it down to just a couple.
And so it's somebody to help you manage basically what your needs are when you might, and this, call it what it is, when we get older, we just think differently and our thought process is maybe slower. And so it's just having that ability where somebody younger can be like, I don't think we need all of that you were talking about there. And just like, let's just narrow it down to what we need and keep focus on. Well, one last question on power of attorney for healthcare, because all this is talked about the hospitals and doctors. So somebody then gets their power of attorney. They've got it. Hey, I've got this for healthcare. Like, but if the hospital doesn't have it, then is it, any good? Is like, so should they like be carrying this with them? Should they give it to the hospital? If they always go to the same provider, like, do they give it what do they do with it then?
Well, if you haven't noticed, most of the providers now have, I think they all were required to change to electronic records at some point years ago. And so now they all have patient portals and apps, and you can log in and see all your things. So if you're techie like that and it's on your mind to be able to get this stuff to your provider the quickest possible way, I always provide a PDF document of the powers of attorney and everything my clients sign to them. And you can upload that to your patient portal. Okay. So it is very important, in my opinion, to get that stuff in front of your care providers. You can make a hard copy and walk it into your doctor's office. All they're going to do is scan it and drop it into your electronic file, and they're going to dump the paper. So as much as you can do electronically, the better. But not everybody is young enough or into technology enough to do that. So whatever way you can get it in front of your care provider's eyes is the best thing. But also, whoever's going to be making your decisions, that's really the person who needs a copy.
Oh, interesting. Good thought. I never thought about that. Like, if you're in trouble, the other person needs, if you need help, so the other person needs to have the document to be able to show them that, okay, I'm the one that's able to help.
Yeah, because you may not wind up at a hospital where your doctor is on staff or under your regular doctor's care. You might wind up at a hospital in Arizona or someplace else.
I'm going to guess very few people have given a copy to their actual power of attorney.
Oh, the agent?
Yeah. My guess.
Yeah. Yeah.
My guess. There you go. Go make your copies. Give it to your give it to your agent, so that way everybody knows who it is, or the backups, right? So if you have 2 parents, like
transparency. Please be transparent.
That's like, it's my parents and I are like super open, super transparent about things. So, I go and sit with them in meetings and doctor's appointments and everything. So like, it's hard for me to grasp not that way, but I understand like kids aren't near. Kids can't fly and be there. Kids, maybe not everybody has kids. So just having that open conversation with somebody, I think, is so important. It doesn't change. It doesn't mean, I just had this conversation, now I'm going to get jinxed, right? It's just like, have the conversation and just be open about it. So that's super helpful. I didn't think about that. Yeah, make sure you give the copy to the person who's actually going to help you out.
I mean, I have a lot of clients who don't even want to give me names of people until they've talked to them. So it's like asking someone to be the best man at your wedding. Like, you have to ask them if it's okay, if they want to participate. We've all seen the movies where, surprise, you're guardian of so-and-so, of my kids. Here you go. And they're like, deer in headlights.
What? Yeah. Interesting. So let's stick on the power of attorney. And the other one that you said was property. Now, this one I'm more familiar with because we deal with this with our clients when it comes to their investment accounts and their retirement accounts, and helping them if, again, one person is incapacitated or deemed that they're not able to do things, that it's that other person that's them helping them pay the bills. But maybe simplify it for us, this power of attorney for property. And of course, when people hear property, I'm thinking, oh, just my house. But what does it encompass? And actually, what can you do with it? And then what's the troubles without it?
So everything. It's astonishing. The document that I utilize has gotten longer and longer over the years, because every time a bank or a financial institution says, we're not going to honor this document because it's not specific enough to the type of account that you're trying to access, attorneys add language to it. So it really covers investment accounts, retirement accounts, any type of liquid asset you could imagine, annuities, CDs, bonds, stocks. But in addition to all of your financials, it covers all of your different governmental transactions.
Like I'm going to sell my house.
Sell your house, what to do with the proceeds, file your taxes, deal with Social Security, deal with Medicare, deal with Medicaid. So your power of attorney property person is generally the one who is going to figure out how to pay for all of the things that your healthcare person is deciding to do. So if I'm incapacitated and I have to go into a care facility, how am I going to pay for that? Do all of my assets need to be liquidated? Are they going to take my house? I mean, there's a lot of questions surrounding how are we going to pay for mom or dad's care if it gets to the point where they can't take care of themselves anymore.
And then say mom and dad need care, or just things have changed. And I mean, unfortunately too, right? I mean, dementia is growing and just darn diseases, but continue to grow. So say they can't, make those calls to pay the bills. Somebody's going to call me to get money to still pay the bills. So that's where the power of attorney also comes in, right? That's hey, I'm the power of attorney for my mother or my father or my cousin or whomever, and they need money out to pay the bills.
Yes.
Comes in there too.
Yes.
Okay.
And actually, I just read an article that was put out by the Illinois State Bar Association. They've got a journal, and I still get a paper copy, and I sit down and read it. And it was about the problems that attorneys have with banks rejecting their power of attorney document. And how you can best go about making sure that your power of attorney is going to be enforceable when it comes time for somebody to be able to use it. So starting off with contacting your bank, contacting you, my financial advisor, and getting that document in front of everybody before it actually needs to be used. So if I just signed it yesterday, I'm going to start contacting my banks and getting copies over to all of those entities and requesting that somebody in their legal department review it and confirm that if my agent needs to come in and use it, are they going to honor it? And what are they going to require? Because there's two different ways that you can have your effectiveness for your agent's ability to make decisions for you kick in.
So like when it starts, when it kicks in. Okay.
Right. So you can either have it effective immediately on the day I sign it. Most people aren't comfortable having that be effective the day they sign it, because that means tomorrow, whoever I name could, in reality, contact my banker and commit fraud against me and pull my money out and steal it. So the other trigger is upon a written determination by a physician that I am no longer able to give prompt, intelligent consideration, those are your buzzwords, to my financial affairs. And that writing has to be dated within the past 60 days. So it's got to be like a current determination. So every 60 or 90 days, however long you put in your timeline, your agent would have to get you reevaluated or have another writing from your doctor saying, yep, she's still incapacitated. Getting that in front of your banks and your financial institutions and seeing if they will accept that language and that type of triggering event and that type of writing from your doctor.
So that way, I didn't even realize that they could. I just thought you have this document and then you take it to places and they have to just accept it. But their rules could say, no, we can reject it based on their legal writings as well.
Man. Every bank has their own different internal guidelines
And we the people, but I'm just saying we, right? Everybody just going through their normal everyday life just wants to pay the bills. They just want to like get
Help.
they want help. That's it.
Yeah. And we make it so difficult.
The biggest example that I could probably share in regards to this is like, I remember, so my grandmother passed away at 95, but like from, let's just say like in her 80s, she's able to like do things on her own just fine. But would she be able to like pay the bills? Like she wasn't able to do that. Like she had her mind, there, and we'd go and have great conversations. But if you're like, you need to pay the ComEd bill and the utility bill, which is now you have to do all that online pretty much.
Right.
I still write checks, but not a whole lot of people do.
No.
But you need to do all that online. And then, okay, what if I move out of this place and pay the rent? Like, it's just too much for her. So like, I'm assuming, unless you tell me wrong here, my mother was her power of attorney for property. So she could write those checks and pay those bills. And it'd even be my grandmother's account. And then my mother's just writing the check on her behalf.
Yes.
Is that what people are able to do?
With the power of attorney, yes.
Okay.
But probably your grandmother probably had it become effective the day she signed it because she totally trusted your mom. And they probably went to the bank together and gave the document to some banker at her bank.
Sure.
Who then had it reviewed and then decided, okay, this is an okay arrangement for us. We understand that you still have your soundness of mind, but you want your daughter to be able to write checks, and here's the power of attorney, and she's going to use that. So again, with the transparency, not everybody is a big fan of that, and you don't have to do it, but it makes things easier.
Yeah.
And that's the whole purpose behind all of these little planning tools that we have available to us, is to make things easier for us as we age, and to make things easier for our children or our loved ones who want to help us.
Yeah.
And they don't want to have challenges and roadblock after roadblock. And why can't I just get a simple check written, right?
So if you don't have it in place, then what happens? Like I understand from our standpoint, but that way, I can tell people all day long, sorry, you have to have this in place, or we need that document. But then what process then would they have to go through? Would the children have to go through to help out mom and dad, pay those bills, pay the property taxes, pay whatever needs to be paid, pay the health bills that are now coming in? What process would they have to go through then?
Well, it's a fun court process called guardianship.
Again?
Yes.
Okay.
So there are two different types of guardianship you can apply for. One is guardian over the person, meaning your day-to-day activities and decisions and healthcare and that kind of thing. And then the other is guardian over the person's estate. And when we say the word estate, I know there's a lot of ideas that people have floating around as to what estate means, but it really just means all of your financial and legal affairs, whatever that may be, however simple that may be, or however complicated. So it's still going to court and petitioning a judge and proving that your parent or whomever is incapacitated. It generally takes several weeks to a month and a half or so.
Plus money. Plus cost.
Yes, which you have to pay out of your own pocket. Someone does, until you can get access to the money of the person that you're applying for the guardianship for.
And what if everybody say, and I doubt it, I'm certain, but what if somebody says, well, fine, I'll just let it go. I'll let I'm sure that they'll just put, they're not paying their bills. I'm assuming you don't pay your bills. Then creditors come in. People are saying, you owe me. So if you're not dealing with it up front, when that person passes away, you're dealing it on the back end anyways, I guess, especially if you want to inherit what they're leaving you.
Right.
And again, that's like saying somebody doesn't want to help up front. We both deal with a lot of great people, and that's not their plan. And they're listening to this going, yeah, now I understand why I want to get this in place. But if somebody just said, heck with it, like let it all go, what then really happens on the back end?
It's a big mess. That's the easiest way to say it.
You've got creditors,
you got
right?
creditors.
Because they're going to say, you owe me for the utility, but okay.
Against you personally.
Oh, that's fun.
So then you've got all these different lawsuits going. If you just ignore all of that, they get judgments. And then they record the judgments against your real estate, if you have any real estate. They can try and attach the judgments to your bank accounts. So, I mean, if you wind up having more debt than you do assets, they will find a way to attach to what you do own and take it away.
Wow.
Through lawsuits.
Okay.
So the real estate, you get liens recorded against it, and then they'll all seek to foreclose, which essentially means get the sheriff to kick you out of the house if you're still there. If you're not, then it's empty, presumably, and take possession of the house, and they can hire a company to clean out all your personal possessions, throw them in a dumpster, and list it for sale on the open market.
Now they own
So,
it.
I mean, it's drastic.
Whoa. And yeah, so yeah, I don't want to go through that process. That'd be miserable. I mean, it's just like you're just actually like a few hours up front saves you tons and tons of headaches and hours on the back end.
Hours and a lot of money.
Yeah.
And if your intention is for your children or other people in your life to inherit from you, there's easy ways to protect it by making sure somebody can pay your bills and just keep everything going. And then when you pass on the back end, there's different ways that you can make sure that things are transferred easily, whether it be beneficiaries on all your accounts. For your real estate, there's a transfer on death instrument that you can sign that's kind of like setting up a beneficiary for your house. And when you pass, ownership automatically just goes to whoever you name in that document. But again, with the transparency, if you don't let people know that you're setting these things in place, they don't know that they're inheriting. And if they don't know that you've left your house to them in that way, there's no governmental mechanism in place to put people on notice.
So it just sits there.
Yeah.
Interesting. Just sits there.
It just sits there.
And I mean, but there's a lot of single people. There's a lot of people that are married without kids. And that's interesting because I think a lot of times they're like, okay, well, I'm going to be really nice and I'm going to list my aunt or my cousin or my brother or my sister or my niece or my nephew as the person to inherit my home. But if they're not having that conversation with them, then how would that person even find out? They don't.
They would have to
Or it's
inquire.
going to take a while. Oh, okay.
Right. Because ownership of real estate is public record. So there's the recorder's office, and that's where your deed goes and gets recorded. And it puts the world on notice. If anybody wants to look up your property and see who owns it, they just can go online to the recorder's website, type in your address, and all the documents recorded against that parcel will come up. And the transfer on death instrument's the same way. So someone would have to be looking at the house. So, I mean, generally, if someone believes they're going to inherit, they can contact an attorney. And if you have a list of assets, the attorney can help you investigate at least the real estate part if there's a transfer on death instrument of record.
Okay.
But the heirs have to know where the assets are and what you owned. So I've had clients come in whose parents were kind of Depression era babies, so to speak, and were very secretive and nervous and a little paranoid perhaps and didn't want anyone to know what they owned. You don't want to invite someone to help you pass on to the next world who believes they may inherit or whatever your feelings are about that. And in those situations, the kids were just left with checking the mail and waiting for statements to come in and boxes and boxes and boxes in the basement of old records and old statements from different financial accounts.
So not added to the list, it's not an essential document, but it's actually telling those that will, and if it's not your kids, then it's going to be somebody that is close to you, but might not be so close to you, like a son or a daughter, then you really need to let them know, like, hey, I'm leaving this to you. You don't have to tell them the value.
No.
I mean, your home, they could probably guess, but like, if it's investment accounts, I'm leaving this to you. If it's stuff in my house, like, just check. I'm leaving you some stuff, right?
There's something.
Yeah, there's something there.
And it's written down, and here's where I keep the writing.
Oh, yeah, that's a good idea.
Right? My recommendation is always a lockbox in your house, a fire safe box in your house. lock it up. You can shove it under the bed or wherever you're going to keep it. Just let somebody know where it is. Otherwise, no one will know.
And if it is your kids, let them know where it is too. Because, okay, so then question on the powers of attorney, and then I just want to shift it over. We talked about the kind of the will first to start, and just the bare necessities here. So, okay, somebody works with you, they put the power of attorney in place. Does that like get filed with the state? Does it get filed anymore? Or is it like what you do with your clients, then that makes it legal, in place document? They're carrying around something that can be used.
Exactly. So another misconception that I get is people think that all their powers of attorney and even their will are filed somewhere. And there's some centralized location that people can go to look up these documents. And there's just not.
Okay.
That doesn't exist. So in my practice, what I do is when a client has signed their final powers of attorney and will, I scan those documents and save them. So I have a copy saved to the cloud forever, allegedly. They take the originals with them. I email them the PDFs of the signed documents, so they've got them electronically as well. But it is up to the client to keep the original safe. I don't recommend a safe deposit box at a bank anymore, only because when the owner of the box dies, it is notoriously difficult for heirs to get into that box. Sometimes the bank will require the heirs get letters of office from a judge, which is what happens after a probate case has been opened, which means you've shelled out about $3,000 at least to get it open and go through the process. It's the same as like guardianship. It's time consuming. It's expensive.
I'm guessing a lot of people have it at the safety deposit box. That's a really good point.
Yes. Yeah. Don't do that. And if you're, it's stuck in that one spot forever.
Sure.
Then, right? So whoever is your executor has to be able to physically go to the bank and convince the banker to let them into the box. You've got to have the key. You've got to be on the special list. Don't let it slip that the owner is dead.
Then no question. Yeah, for sure.
Well, and sometimes even if the owner is deceased and you're on the box as an authorized person, your authorization extinguishes when the owner dies. Depending on the bank's internal rules, right? They all have different rules and we all have to comply with whatever they say, which is another reason where if you're going to keep stuff in a box, take your kids or whoever to the bank with you and then find out if they're going to let them in when I'm dead.
What are the rules?
Yes.
Okay. All right, let's move on to the one thing that we talked about kind of starting and we moved into powers of attorney, but a will. Here I need to have a will in place. Why? Just, again, I'm going to pass away. What does the will even do for me? But I can see powers of attorney now, right? Like I'm alive. I need help. I can see the powers of attorney. Probably should get those, make sure that those are in place because I'm going to need help while I'm alive. But what the heck does the will do for me?
Well, not much. I'm kidding. A lot of people think if they have a will, that will keep their estate out of probate. And unfortunately, the only thing a will does is it gives me the ability to name who's in charge after I die. And it gives me the ability to say who's going to get all my stuff. Primarily my assets, meaning accounts, real estate for sure. And then you can also list out if you want certain people to get certain items of personal property. So
if I have like specific, I can just think like women have jewelry. They might want it to go to a daughter or they want something to go to their son or specific people. So like the will's what names that out?
Sort of.
Okay.
The will names the executor, and the executor is in charge of carrying out the wishes in the will. The will allows you now to designate personal property in a handwritten memorandum or side letter. I provide that to my clients when they come in to sign their documents. It's essentially like a table in Word, and it's got a column for item and a column for person. And so you can handwrite items and then the person you want to receive those items, and it's up to your executor to locate the items after your death and then get them passed out. and get a receipt from the person receiving it so that the executor has proof that they actually got what they were supposed to.
Sure.
And it can include things. I've had guys denote tools, electronics, watches, old medals from the military. So different families have different things that are important to them from sort of a heartfelt,
emotional standpoint.
Yes.
Yeah.
Yes.
Now, you're saying at the beginning, and I know this because of just what we do for our business and of course working with you in different seminars, but the will does not avoid probate. Now,
Correct.
Again, because we know this, but I think a lot of people talk about probate. They say the word probate and they're like, I want to avoid probate. But like, I really don't think I don't know. Let's just say somebody has no idea what probate means. Like, bringing it all the way down, what the heck is probate?
So probate is the court process for the administration of someone's estate or their assets after they die. So for instance, my husband's grandmother had a trust in place and all of her assets were in the trust, but she lived until she was 99 years old. And she had some accounts that no one knew about.
Oh.
And they weren't in the trust. And they had beneficiaries on them, but they were her husband who had died 45 years earlier. And she didn't name a backup beneficiary. So we've got a couple of different accounts amounting to a couple $100,000, say. And there's no beneficiaries on them. And they're not in a trust. So they're sort of hanging around unclaimed. The only way for her kids to be able to get at that money after she died was to take her will and file it with probate court and petition a judge for the authority to act as the executor. Because just because you name someone as executor in your will doesn't mean that that person is going to be fit to be your executor when you die. People have health problems or go to jail or whatever, right? So they've got to petition a judge. And there's certain people entitled to notice that this process is happening. So your direct lineal descendants. So spouse, children, if you don't have any children, your siblings and your parents, everyone is entitled to written notice that this process is happening. And then they have to sign off that they have gotten that notice, and that has to be filed with the court.
So everybody now has access to those dollars that kind of didn't have a beneficiary to them. Even if her wishes were, well, my husband and then my whatever next in line, but sounds like everybody then can kind of come after it.
Well, they have noticed that the process is happening.
Okay.
And they have to sort of subject themselves to the jurisdiction of the court. And then once the case has been opened and the executor has been appointed, the executor's job then is to contact Schwab or wherever the money is sitting and let them know that a probate case has been opened. And then Schwab, for instance, cuts a check payable to the estate. And the executor has to get a federal tax ID number for the IRS for the estate. They have to open up a bank account using that tax ID number. And that is where the money goes that comes from all the unclaimed accounts.
Okay.
And then that estate has to stay open for 6 months because creditors have 6 months to file claims. And a notice has to get published in the local paper once a week for 3 weeks. So there's 3 legal death notices. And any creditors who may be scanning the legal death notices, which they all do it, if you owed them money when you died, they file a claim and creditors get paid first. So they've got 6 months to file claims. So that money has to sit there for at least 6 months. So now you're adding time to the administration. At the end of the 6 months, if there's no claims filed, then the money can be distributed to the people named in the will who were supposed to get money.
Okay.
So if it wasn't any of the heirs who were entitled to notice that the process is going on, if they were disgruntled and unhappy, they could sort of the way a spouse in a divorce could make it drag on, they could make the process drag on.
Okay. So the will can then set the beneficiary, if I'm hearing this, like the will kind of sets the beneficiaries also for, call it, monies that might be out there or things that might be out there without beneficiaries listed to them.
Yes.
So let's just go back to your example here. If there was no will, there's no beneficiaries listed, then what happens?
Then it's kind of like the whole guardianship thing where you rely on someone volunteering to be the administrator. The administrator is the same word that we use for executor. It's just executor is only a term you use when there's a will. If there's no will, someone has to volunteer to administer the estate.
Which is just watching over it all.
And it's the same court process.
Okay.
So you petition a judge, you give notice to everybody, and then the distribution goes according to Illinois statute. So Illinois has a designated plan for where all your money goes when you die.
Which is where who would it, like say there's parents with children, who would it go to?
So, for instance, I die and I have no planning in place. I'm married and I have kids. Half goes to my spouse, half goes to my kids in equal shares.
So you've essentially, if you wanted everything to go to your spouse, you kind of disinherited them by half?
Yeah.
Huh.
Goes to the kids.
That'd be a surprise.
Yeah.
I mean, they're your kids, but it'd be a surprise.
They're right.
Yeah.
Yeah. Their dad really should be the one who.
Right.
Yes.
Yeah, managing over that. Okay.
Yes. Yes. And if I die and I don't have any kids and I'm married, it all goes to my spouse. But if I'm not married and I don't have any kids, then it finds your nearest living blood relative and half goes up your family tree to parents and then laterally to siblings. And then it kind of tentacles out from there. So nieces and nephews, cousins, aunts and uncles, things like that.
So there's like a line in place, but I mean, it literally could just sit in a process for, sounds like a long time because everybody's got to figure out the line and who's still alive and who might not be and where's everybody at? What's their, that just sounds like a lot.
Well, and I do have heirs who come to me sometimes and they're like, my dad died and, you know, my brother and I are here, but I don't know like what he owned or if there's beneficiaries or who inherits. Can you help us? And it's like a half blind person leading blind people because I don't know what assets dad had when he died.
Sure.
So I've got to start digging around and telling them how they can start digging around, but there's really no way to know if you got it all.
Yeah. And let me bring in like another example, kind of, again, let's say you have a will. And so you're mentioning earlier, you talked about the transfer on death instruments, so you can list beneficiaries on your property. We, with like investment accounts, IRA accounts, beneficiaries there, because I know we were talking about like accounts earlier. Accounts with beneficiaries go to the name of the beneficiary.
Yes, so beneficiaries trump everything.
Okay. So property, you can put, depending on probably your state, but you can list beneficiaries on your property. Sounds
yes,
like
most states have that ability.
Okay, and then your accounts, but then somebody might say, well, then, okay, if I have a will in place, and well, maybe we'll go both ways. I have a will in place. What about my car? What about my boat? What about like all of these like small things? Do those then sit in probate still?
Not necessarily. If the value of all of those smaller assets like vehicles or boats, things with a title, if those total less than $100,000, then it's still recommended that you have a will because your will at least gives you the ability to say who's going to be in charge of those assets and who's going to inherit them.
Okay. Kind of naming the beneficiary in a way.
Yes,
okay.
On your will.
Yep.
But the way that you can circumvent the court probate process is using, Illinois has a small estate affidavit, which is a sworn statement by the executor of the will swearing that these are the only items that are outside of a beneficiary kind of estate, and the total value of them is less than $100,000. And then you list out if there were any debts. All the debts have to have been paid. So like burial, funeral, those kinds of things, taxes. And then who the beneficiaries are according to Illinois law. So the person's spouse or the person's children, or if you have to tentacle out to parents and siblings, they all have to be listed. But you can attach the will, and then you walk that document along with the will into the DMV. You've got to have the title to the vehicles.
Okay.
This would also include like a mobile home. So sometimes if someone lives in a mobile home and they own the mobile home, but they rent the piece of land that it sits on, same kind of thing. Because a mobile home is essentially a vehicle. Like it has a title.
It's mobile.
Right. So it's registered the same way that your car is registered.
Okay. And then, all right. So sounds like there's some kind of workarounds, or you just have it in the will. So then the will's like, oh, yep, it's listed right here. So this is my piece of property now, the car or the boat or whatever it might be. Is that what I'm understanding?
Yes.
Okay.
Yeah, but
But
only
if you didn't,
way to
then it's like going back
Probate.
through the probate. Okay, back through the court process. If you have the beneficiaries listed on your property through the transfer on death instrument, does that still go through probate?
No.
Oh,
No.
that's nice.
Yes.
So just the other, so it's all the miscellaneous then is why it would go through probate. And if somebody wanted to avoid probate, then what would they do?
Make sure you've got beneficiaries listed on everything.
Okay.
Is always my primary recommendation. And if you have real estate or assets that your plan is to sell them and have the proceeds distributed amongst a class of people, perhaps in different percentages, the only way to avoid probate on that is to create a trust.
So with the transfer on death, it's if there's 3 people listed, it's all split evenly.
Well, they own that property together when you die.
So they decide what they want to do.
So I only recommend that document if everybody gets along.
Oh, okay.
They have to be, responsible people, because it's like they bought an investment property together and it's immediately subject to any of their creditors. So if one of them is what we call a spendthrift or has a lot of debt, you don't want to set up the other 2 people with the problem of the third person's creditors attaching to the real estate before they could sell it.
Oh, man.
Or if someone's living there, but you want maybe all 3 kids to get it and figure it out. Like the one that's living there has to buy it from the ones who don't want to live there. Just make sure that you're giving it to people who have jobs and would be able to get a loan and wouldn't just hole up in the house and refuse to move and not pay for anything, because then you're setting up everybody for problems.
Sure.
And the whole point of doing all of this is to avoid problems.
And you mentioned kind of look at it like an investment property, but let's say, and I know I'm going down like a ton of rabbit holes here. We started off in will.
Here for.
Yeah, but what if it is an investment property? So then, just based on what you're saying, I mean, it's got costs to it as well. Property tax, you got to keep it running, whether it's utilities. Who pays for that? Or is that where now everybody needs to get along and say, hey, the bills this year are $5,000, so you owe $2,500, you owe $2,500. If there's 5 kids, you each owe $1,000. Is that?
Yeah. That's exactly how it works.
Okay.
So when I do the transfer on death instrument for people, it's usually because they've only got one child and everything is going to that one, or maybe 2, and everything is going to the 2 of them. I recently had a transaction where there were 5 adult children who were beneficiaries on the transfer on death instrument. One of them died. So then we were left with 4. And they did all get along and they did all agree to sell the property. But it can become cumbersome because not all of them lived in Illinois. But they all have to sign the listing agreement. They all have to sign the sale contract. They all have to sign the
So
deed out.
Somebody from another state's like, this isn't fair. I'm not going to use it. We're not traveling there. We don't want that piece of property. Then one person wants to sell and
It can
create a mess.
create a mess.
Sure.
And And sometimes when the people I'm meeting with, the clients, are making the plan, they're like, well, I've got a life insurance policy, I've got my retirement accounts. They're going to have plenty of money to pay for carrying costs until they can get it sold. And that may be true, but they all have to be able to get along with each other well enough to coordinate who's paying what bill, or is one person going to pay it all and the other two are going to reimburse, or how they're going to work it logistically.
Gotcha.
Yeah.
Okay. And then if somebody just wants to avoid all of that, what do they do then?
Trust.
That's the trust.
That's a trust.
All right. I know I could go down I could go down that rabbit hole for probably a whole nother hour. So we'll have you back. Hopefully, if you come join us, we'll talk about it. That'd be awesome.
Okay.
But a few things that you talked about earlier that I think, so have some clients that are like retiring early, let's say in their 50s. And you were talking earlier, which it just like then hit me, because you're talking earlier about guardianship. So this might be in reverse, right? So we're saying, oh, we need to go potentially get I know my parents have their documents in place, but if they didn't, I would have to go get guardianship of them. But what if you have, whether maybe they have an adult child or they are in their mid 50s, maybe they had children later in life, right? So their kids are 16, 17, who knows? What about younger children? Like what, I would assume it's documents that you put in place to have guardianship. But what if there's nothing in place? What happens then?
Well, so.
Even young children, adult children, just, right? Somebody that they're responsible for.
Right. I've got two different scenarios present in my mind right now. One is the more common, stereotypical, I've got two young kids. What if my husband and I die tomorrow? Who's going to take care of them? Who's going to take care of their day-to-day care? And so where you designate who you want to be in charge of that is in your will.
Okay.
Because no one can become legal guardian over another person unless a judge signs an order ordering that to be the case. So just because I name someone guardian in my will today doesn't mean that 10 years from now they are going to be fit to be a guardian over my children. So if I don't get a chance to change it or whatever, what happens is if we should both pass, the executor files the will with probate court and opens up a particular guardianship case. And then the judge assigns a person, it's an attorney with a little extra training, to do a little investigation. And so the attorney makes a home visit into the person's home where the guardianship is going to sit and does an investigation, does some interviews, maybe interviews the kids, maybe interviews some neighbors or other family members. And then the attorney writes a report. So the attorney is called the guardian ad litem, and they're acting as the eyes and the ears for the court. And then they create a report and submit it to the judge. And then the judge has that attorney into court and questions the attorney about the findings, or if there was anything unclear in the report. And then when the judge is satisfied that these guardians are fit to act, the judge will then give them guardianship. But that guardianship has extended responsibility. So generally there's like a 1 to 3 year reporting period. So the guardians have to go back to court every few years and report to the judge how things are going.
Okay. And this is if you have it listed in your will?
Yes.
What if you don't, though?
You need someone to volunteer to be the guardian and petition the judge. So someone needs to be proactive enough to jump in and start doing these things.
Say, hey, I'll help out. I'll take over.
Yes. And there's a statute that has preference for who the preferred guardians are. And it's always your direct lineal family members.
Okay.
So parents or siblings.
But I can even see that becoming, hopefully
contested?
Everybody gets along, but you could say like, you could have parents going, well, we'll take care of them. Siblings going, no, we'll take care of them. That could be. And
then her parents and his parents. And there's a lot of different players potentially.
Maybe a whole nother episode.
On guardianship,
but that's just good to know, like nothing in place, potential issues. And it's just potential kids that are going through probably the worst time of their lives and just want help.
Yes.
And need help.
And then there's the scenario where, and I have several clients who have children with special needs who are over the age of 18.
Mm-hmm.
And when they turn 18, the parents have to petition for legal guardianship over them.
Oh.
And so if I've got legal guardianship over my adult child and I die, what happens to them? They still need a guardian. And there is a way that in your guardianship case where you report every few years to the judge, you can work with the court to appoint your successor for who you want to take over when you die. And that's a whole other issue. Yes. But if you've got that scenario, there is a way that you can make it easier.
Okay. Very helpful, because I don't think a lot of, that's why I was saying earlier on, like people go, well, we don't need that. And to think how many people have, hopefully healthy, right? Like gotten through life. But what if something would have happened, right? Because they don't, so I would say 25 to 50% of the people that sit down that we meet with sometimes, they just don't have anything in place. And how many children do you have? Well, we've got this. And it's like, wow, like good thing nothing happened, through those younger years. And very interesting. So, all right, wrapping up, bare essentials, power of attorney documents, for sure.
For sure.
The will.
You gotta have a will.
And then we're going to have you back. We're going to talk about trust.
Because that could be necessary even if you don't have a lot.
Yeah. And even if you do have a lot, that could be necessary too.
Yes.
Right? Illinois estate
Especially
tax
if you have a
issues.
lot.
Yeah. I mean, then really a lot of things come into place there. Very helpful. Well, thank you for coming, talking about it all. Appreciate it.
My pleasure. It's what I like to do.
Where can people find you? And we're, just so everybody knows, we'll link to it in the description of the YouTube video. We'll link to it on the podcast show notes. Our website is lifemoneyshow.com. So we'll have all of the links like in the show notes there as well. But if somebody wants to find you, where can they find you? And we'll make sure we link out to it as well.
Well, you can Google me, thanks to my husband, at Lauren Jackson Law. My website is www.laurenjacksonlaw.com.
Well, that's pretty simple.
Yeah, it's just me.
Perfect.
Yes.
Yeah.
I've got two offices, one on Main Street in St. Charles, so North Avenue, and the other is right across the street from your office in Elgin on Point Boulevard, which is Randall and 90.
Great.
And
then do you do out-of-state work as well, or no?
So
it depends on the state, maybe.
Well, technically, I'm not allowed to prepare documents for people residing in other states. But if you're an Illinois resident and you spend a lot of time in a different state, any wills or trusts that you create here will travel and be recognized in another state. I recently had an attorney reach out to me who has clients who live in North Carolina like 49% of the time. The remainder they're in Illinois. And so now I'm working together with an attorney in North Carolina to get documents in place for those people. So trusts generally are more federal law, and those I can do for people out of state. Otherwise, it's Illinois.
Great.
Yeah.
Well, if you're, in Illinois, wondering about your estate documents, getting your estate documents in place, obviously Lauren knows not only the bare essentials that you need. We're going to have her back. We're going to talk about trusts. We're going to talk about guardianship. I know that there's a multitude of trusts, especially if you're looking at the Illinois estate tax that you need to have in place. But I think there's, and I think you said it great earlier too, is like, trusts aren't necessarily, I think a lot of times people think, oh, well, trusts are because you have to have a lot of money first, but not necessarily. It can all just be the dynamics, let's say, like the dynamics that you have going on in your life or where you want things to go, how you want things to go. So would love to have you come back, talk all about that, because I know we could probably talk for another hour in regards to that. And I'm sure people are like, yes, I want to know, why do I need a trust? When does it come into place? What does it, what are the benefits that it brings other than just keeping me out of probate, which I know is a big benefit. But good news, like you said today, if you've got that transfer on death tool, then you don't necessarily need it for your piece of property.
I've surprised a lot of people by saying you don't need a trust. They walk into my office and they're a little like, I really thought we were going to do a trust today. And I say, I really don't think you need one because it's very simple. Everything is going to one child. Mm-hmm. And the child is healthy and capable. So it really just depends on
everybody's situations,
what you've got and who you want to inherit.
And I find with all of this, like that's when emotions start to come in play. So if there's like one child, it's like, and that's where they want it to go. It's like, okay, little emotions, not a big deal. It's all, let's just keep it simple then. But then you've got multiple kids and multiple grandkids and maybe you like some family members, maybe you don't. Hopefully you like them all, but
not all personalities mesh.
Yeah, good point. So, all right, we were going to have you talk about that. Okay. What else was on my mind the other day? Titling of assets. Let's just say we knew somebody the other day that they were putting, and I'm sure somebody's listening to this, and I want them to listen back in if we're talking about this, but it was their names and their child's name on their bank account.
Oh, as co-owners?
As co-owners. And the bank account wasn't just like, $3,000. There's a lot of money in there. But there was actually 2 children. And so we had this conversation that you literally just disinherited the other child.
Yeah.
And so let's talk about that
sometime. Oh, but they get along and they'll share.
Somebody told me it goes from grief to greed, unfortunately.
Oh, I've never heard that, but it's very good.
And so I was like, you know what? That's unfortunately
it happens
true.
All the time.
Yeah. So, all right, we're going to have you back. We're going to talk about it all.
Good.
Thanks for joining.
Thanks, Scott.
And everybody have a great day.
Have a great day.
Insurance products are offered through the insurance business Sierens Financial Management, Inc. Sierens Financial Group, Inc. is an investment advisory practice that offers products and services through AE Wealth Management, LLC, AEWM, a registered investment advisor. AEWM does not offer insurance products. The insurance products offered by Sierens Financial Management, Inc. are not subject to investment advisor requirements. AEWM and Sierens Financial Group, Inc. are not affiliated companies. Investing involves risk, including the potential loss of principal. Any references to protection, safety, or lifetime income generally refer to fixed insurance products, never securities or investments. Insurance guarantees are backed by the financial strength and claims-paying abilities of the issuing carrier. This podcast is intended for informational purposes only. It is not intended to be used as a sole basis for financial decisions, nor should it be construed as advice designed to meet the particular needs of an individual situation. Please remember that converting an employer plan account to a Roth IRA is a taxable event. Increased taxable income from the Roth IRA conversion may have several consequences, including, but not limited to, a need for additional tax withholding or estimated tax payments, the loss of certain tax deductions and credits, and higher taxes on Social Security benefits and higher Medicare premiums. Be sure to consult with a qualified tax advisor before making any decisions regarding your IRA. Sierens Financial Group, Inc. is not permitted to offer, and no statement made during this show shall constitute tax or legal advice. Our firm is not affiliated with or endorsed by the U.S. government or any governmental agency. The information and opinions contained herein provided by third parties have been obtained from sources believed to be reliable, but accuracy and completeness cannot be guaranteed by Sierens Financial Group, Inc.
Scott Sierens Financial Group, and AE Wealth Management, LLC are not affiliated with the Wall Street Journal, Fidelity Investments, Charles Schwab, or the New York Times. Lauren Jackson and Lauren Jackson Law are not affiliated with Sierens Financial Group or AEWM.